Be seated, please. Please be seated.
Ladies and gentlemen, I hope you enjoyed your lunch. We're ready to resume the trial of the case. The state will receive Mr. Boyd.
Thank you. Justice. I'll be happy to talk about justice. Justice for that little boy. That 22-month-old child whose life was taken from him. The defense wants to talk about what could be more beautiful than the words, not guilty. I'm sure to the defendant's ears, this plan would work. That's not justice in this case. Justice in this case is nothing more than justice for that little boy. And in this case, it's a verdict of guilty on all counts. The defense talked about it's a hard thing to do. No, the hard thing to do is what you jurors have had to sit through for weeks on end. Having to sit here and listen to gut-wrenching testimony, officers, and strangers who cared more about that little boy on that scene than the defendant did. What's the hard thing to do? And I know it wasn't lost on any of y'all. That little video played there at the end with the defendant playing with the guitar with Cooper. Something the defendant cared more about bringing into his workplace on June 11th after stopping by Chick-fil-A than he did his kid a week later. You want to tell me about justice? The only justice in this case, in this courtroom today, is a verdict of guilty on all counts. Now, before I sat down in my first part of the closing, I posed several questions for y'all to be thinking about. And it's funny, I was thinking over the lunch break, I wonder if the defense actually addressed these things, because these were very important, crucial parts of their case in opening and things throughout the case that they told you were going to be something to pay attention to. Was the defendant sexting before he got to Home Depot on June 18, 2014? They never directly answered that. Because, as they like to say, they got it wrong. One of the biggest cruxes of their case, they got it wrong in opening. Because he was, and they got it wrong, and they can't admit it because he is guilty. To admit that would be to admit guilt. Did the defendant live a double life? Yes, absolutely he lived a double life, and we know it. They don't want to say it, but the evidence shows it. How many things did Dr. Brewer agree lessen the likelihood of a failure of memory systems? Didn't address that once. And that car seat. Is this how the scene looked on June 18, 2014? If that's how it is, based on the defense's own experts, the defendant is guilty of all counts. At the end, they talked about this whisper post. Well, he posted stuff all the time. He responded to whispers all the time. But guess what he didn't do? He never said he did an escape from his son until 10 minutes before he killed him. Not any of those random posts. Right then, what was in his head, 10 minutes before closing the door on that child. That's how he was feeling 10 minutes before doing it. In the last responses, that agreed hug, he is still in the car, carrying on a conversation about his son, and he's acting like he don't remember. Said that this post was a leap to murder. If y'all remember the testimony about the timing, this post wasn't even discovered. This wasn't even in the state's evidence. We didn't get the ability to look at that conversation until well after the indictment. This wasn't a leap to murder. Murder was already there. From the car seat, to lunch, to the video, to the motive, to the mountain of evidence in this case. Why do we bring all this stuff in here about his double life? Imagine a jury not knowing the other side of a defendant in a case like this. That information being withheld from a jury. That jury would be offended not to know who this person really is. All right, now just a brief timeline to go over some time so we're clear on what the times are that we had in this case. Just on June 18, 2014. 12 a.m. to 12:51 a.m. During that time, the defendant was sexting with numerous people. He sent one work email, did one search, and this is key, for the cost of a child passport. Remember, his brother had already gotten passports for the kids and things like that. And we'll talk about this whole vacation thing in a second, because I'm going to address everything that he said. One search, cost of a child passport, then followed up by more texting, sexting, things like that, till 12:51. 5:30 a.m. approximately around that time, per the defendant's story, the child wakes up. Cooper wakes up and then goes back to sleep. Sleeps in late. 5:40 a.m. around then, he starts sexting again. And importantly, that morning, in the hours there with Cooper at the house before he goes to Chick-fil-A, he sends one last message to Janie Meadows, who's broken his heart, and she doesn't respond. 6:30, you heard that his wife wakes up. 7:15, she leaves. And at about 7:20, 5 minutes after she leaves, he starts messaging again while he's supposed to be watching his child and getting ready. And going back to this, and we're going to get to it in a second. I know I've got it written on my PowerPoint somewhere. They brought up Elizabeth Smith again. Elizabeth Smith, he was going to set up a rendezvous with her, I think is what they called it. Y'all look at the messages. That was like 7:25 a.m. That was way before he even left the house that day. So, just so we're clear on the times. All right, 8:30 to 8:59, around that time is when the defendant left for and was traveling to Chick-fil-A. He was messaging others on the way and responded to one email. One email. And at 8:59 a.m., the defendant brings Cooper into Chick-fil-A. From 9 to 9:20 a.m. approximately, the defendant is in Chick-fil-A eating with Cooper. During that time, he responds to a message from Magnolia Blonde, a woman he'd been carrying on a conversation with earlier, sexual in nature. And at 9:15 a.m., he says, "I love my son and all, but we both need escapes." That's the time. Undisputed times, 9:20:30 a.m., the defendant and Cooper walk out of Chick-fil-A. And these are all times confirmed. Confirmed that these were accurate. Confirmed by Greg Sanders at Home Depot. Confirmed by R.B. Smith with Cobb County Police, checking the times of the phones, checking the times of the receipts, checking the times of the videos at Chick-fil-A, and accounting for any difference in time. He continues the conversation. Agreed hug, we both need that, at 9:24:28, while still in the car with Cooper. 9:24:42 a.m., he first appears on one of the treehouse parking lot camera videos, coming in the side area. 9:25:38, car comes to a stop, and at 9:26:15, the defendant shuts the door on Cooper. And you saw all that time in there he was sitting. Over 30 seconds in the car with that child. And you remember the defense showed you that one video where he parked kind of up close and he's in the car for a while? Y'all remember seeing how he was in there moving around, going to get this, going to get that? There ain't no way he missed that child. 12:41 to 12:43. Defendant goes back into the car, throws light bulbs, stops on the way. 4:16 p.m., the defendant drives away. As we said at the beginning, I know it's good to take in all perspectives. In this case, luckily, the police didn't just come in and take the defendant's word for it about what happened. They knew something was wrong. You take one look at that car seat and you know something is wrong. Now let's get this square from the get-go. That defendant, when he had his probable cause hearing 2 weeks after arrest, 2.5 weeks after arrest, which somehow magically got moved up, without anybody consulting the police, he's still only charged with a negligent homicide at that time. We talk about a rush to judgment. They had the evidence they had, but he had only been charged with a negligent homicide at that point because the investigation was continuing. He wasn't charged with the intentional homicide until it goes to grand jury. So perspectives. This wasn't just based on the defendant's statement, motivated to try to lessen his culpability. Cooper's perspective, the evidence at the scene, patrol car video, witnesses, video evidence, computer and phone evidence. Now let's talk about some of the defendant's arguments. I could sit up here and go through every witness that has testified, and you would probably all jump out of that jury box and come try to kill me. Because y'all have heard the facts, and y'all are ready to get to it. I understand. But I would be remiss if I did not go over and address some of the defendant's arguments, because they don't need to be hanging out there because they're wrong. First of all, Leanna Harris. Leanna Harris was never going to accept that her husband was capable of this. Leanna Harris stayed with this man for years. You saw how she is. She finds out her son's dead, and the first thing she asks about is her husband. You have to feel some sort of, she kind of got treated like a doormat for years. And to say that she shouldn't have been, the police shouldn't have looked at her and her actions as suspicious that day, ladies and gentlemen, she admitted it from the stand. Yeah, when I watched that, absolutely. That doesn't look right. So the police should just ignore it. Absolutely not. The fact that his friends knew about his problems, we heard that. His friends knew about his problems. They didn't know the extent of this. You heard from every one of them, as much as they tried to say, you know what, he had a porn addiction, this or that. None of them knew the extent of what life he was leading in June of 2014. Demeanor. They want to talk about demeanor. Okay. They say he was broken in that police interview room. He used to work with the police. You don't think he knows he's being recorded in there? Come on. He's huffing and puffing, and you saw his behavior there. You saw his behavior at the scene. You saw his behavior in that patrol car. And you go back, and the defense said, you can watch videos. Heck yeah, anything that y'all want to watch and review again, you can. If it's important to you, we ain't hiding from it. Review whatever you want. Because you look at that patrol car, and you see exactly what's going on. You look at that interview, you see what's going on. And then you see the difference, and when we get real emotion from this man, when he's been arrested, and he knows the jig is up. Child free. Okay. Tell me this. 2 weeks after a person has left a child in a car, you've got all this evidence coming up. A detective would be insane not to think that a typing in of a website called Child Free is not something that should be addressed. And 2 weeks after, at a probable cause hearing, Detective Stoddard told a judge just that. Now, he said he didn't know if it was search or it was this or that, but we found out what it was. We found out he actually typed it in. And he said at that hearing, yeah, it was back in April. But yes, that is something that somebody would want to know. Now, of course, it was the detective's investigation that found out, okay, his friend suggested it. Let's be clear about this. Defendant typed in that website. And after he said grossness, he still went and reviewed 2 other articles on that website that espouses living a child-free life after he says grossness. So let's just be clear about it and be completely honest about it. Because the state, we didn't even bring that up in opening. The defense puts it out there, so of course we're going to address it and say, hey, yeah, this was here, and we admitted, look, this is why it was here. They argued about that the defendant would have deleted information from his phone and things like that. First of all, y'all know from everything you've heard about him, from even his friends, he's this grandiose personality. He gets mad when people in a restaurant, his friend may know more people and things like that. He's a know-it-all. He never thought the police were going to get onto his act. He knew all along, I'm going to be an advocate for this. Also, as one of the witnesses told you, somebody who has, and y'all know this, someone with an obsession like this, what was most important to him in his life? What was most important to him? Do you really think he was going to go delete all that stuff he had accumulated over the years? These pictures of random women? These conversations? Absolutely not. Because that meant more to him than that child. And then, if you remember, several times throughout the investigation, both at the scene, with Detective Piper, Officer Piper at the time, in the car, even with the detectives back in the interview room, he kept trying to finagle his way in to get access back to his phone. Well, I need to call some people. Well, I need to get some numbers off of this. Because he realized once he got detained, this is not going how I planned. And criminals get caught all the time. It's one thing to say and come up with a plan and say, I'm going to do A, B, and C. And it's a whole other thing once you pull the trigger. It's a whole other thing when you actually have to look at your dead son in the car. How are you going to react to cover this up? Okay. Detective Stoddard lied. We've heard that over and over and over again. Let's get a couple of things clear right off the bat. That whole thing about Detective Stoddard, now he's sitting right there. I'm going to talk about him because he's sitting right there. Y'all saw him. He got testy up there at the stand. He got a little bit out of shape. He's been investigating the death of a 22-month-old child for over 2 years. He has been living this case, pouring his blood, sweat, and tears into interviewing everybody under the sun that he can. And this is what he has to deal with. The definition of the word research. All this is founded on the definition of the word research. Ladies and gentlemen, that's exactly what the defendant did. He researched this evidence. The Detective Stoddard never, ever, ever, anywhere, and we cleared that up, said that he Googled this or anything like that. Let's look at a basic definition of what research means. The definition of research includes any gathering of data, information, and facts for the advancement of knowledge. That's exactly what he did. He goes to a website. He sees a video that's called How Hot Does It Get in a Parked Car? He has interest in it. He clicks on it. He gains information to advance his knowledge of how this works. He had gained information from watching an advocate. He had gained information from getting these emails. So this whole thing is a farce, saying that the detective sat there and lied at a probable cause hearing when he said he researched this. Because that's absolutely what he did. They're lawyer games, to be quite honest. They're word games. Absolutely. Let's go to another one. Let's go to another one of these. He lied when he said he was in the frame and that he had a clear view. What did he say? What was the first witness, crime scene tech, Shumpert, the first one to come out and take pictures? And Greg Sanders. When you're in the frame of the car, there between the door and the car door and the inside, in the frame of the car. When you're in the frame of the car, do you have a clear view? Absolutely. No doubt. Now, at the probable cause hearing, And we'll put it in context in a second. Well, what did he mean by that? He always said he's in the frame of the car. He never said he put his head in that car. He never said he actually saw something. What you have is the defense playing word games and not putting it in context. So I asked them, are they lying to you? Because what they did not talk about in their defense was the rest of his testimony in the probable cause hearing. Remember, I had to bring it out and show it to him where he was asked those questions. And he said back then, at that date, no, his head never was in the car or anything like that. It's premised on lawyer tricks. That's absolutely what it is. The phone called Little Apron Academy. Officer said that these are officers on the scene and citizens that said it looked like he was talking on the phone when they showed up. Detectives have that information. They look at the phone records, and there's a phone call to Little Apron Academy to that toddler room that's 5 to 6 minutes, depending on what type of record you look at. Of course they're going to follow up on that. They went and followed up to see what would happen, to see if maybe voicemail kicked in or this or that. No, the phone would ring and ring. It would not stay on for 6 minutes. Obviously, what would have happened is that he made a call, it got connected, and then it stayed on after the phone got taken out of his hands. Because you see, that time of that call was before he got detained. Now, Michelle Gray, honestly, who knows if anybody talked to him? I don't know. The police don't have an answer for it either. Michelle Gray admitted to you, yes, when you looked at it in its entirety, all the evidence, it does look suspicious. The defense would just want you to not follow any angle in this case and sit on their hands. He did exactly, Detective Stoddard did, what even Michelle Gray says he should have done. And you saw that slide they had down there. I think they clicked it real fast and didn't talk about it because it was wrong again. Because they argued, oh, you know what it was? The police must have hit redial when they took the phone. Well, we know that's not true because there are 2 phone calls in the records. And if you remember, the defendant, in his own statement, corroborates that and says, I called Little Apron twice. So them trying to put that up on that board is completely false and untrue. Okay, the smell. Let's talk about inside the car and outside the car. Who are the 3 people who went inside the car on the evening of June 18, 2014? Lieutenant Farrell, Detective Stoddard, and Carrie Grimstead. So all 3 of these detectives are going to come up here and risk their careers and make that up. Y'all saw the demeanor of those officers, those detectives. Those were the only 3 who went in there, of course. Now the defense is saying, well, Shumpert was right up there. He told you he never went inside that car. He had his camera out and was taking pictures from outside the car. And in addition to that smell inside the car, we have corroboration from Dr. Frist, who told you and explained during cross-examination, I know they didn't want to hear it, but explained what you would get upon opening that door to that car after that child out there baking in the sun for hours. The gas is being released from that child. The sweat. The urine. Call it what you want, decomposition, death, urine. There is no doubt when he got in that car, it was going to be wretched. And then even that, not even just inside that car after it's been closed up, at the scene, this child, the people who got down with that child, and he's talking about firemen and people like that. There was no testimony that any of these people got up on that child, any of these random firemen. You had Peyton Barwick who came up to assist the child. You had the officers who told you, we were concentrating on trying to revive this kid. What do we know, in addition to Detective Grimstead, Detective Stoddard, and Lieutenant Farrell? When they got down by that child, even though the child had been out in the elements for some time, out there in the open, you had Martin Jackson, said that child had a smell, urine, diaper, whatever, coming from that child. Crime scene tech Shumpert, and James Hawkins, a man who you saw carried this burden realer than almost anybody here, who lost a child before, and who sat there telling you while he was trying to save his poor child's life, trying to breathe life into this little child, not giving up hope even though it was obvious, the defendant was gone, walked away. Okay. The parking lot. They talked about this being a choice parking lot. We already talked about it. Y'all saw the video. All the other spots, that spot was open. None of the other ones were. That was a spot where there was only one possibility of having a car parked anywhere around him, the way it was positioned, and there was already a car there. That's where he backed up, pulled around, and pulled in. And then we talk about the wood line. If he would have backed into all that shade, if y'all remember from the video and everything, there's a huge wood line right there. The shade is coming because the sun's on the other side. If he'd have, that child, the car never would have gotten a bit of sun if he'd have backed into that wood line. We talk about passersby. You got these people walking by a car that has tinted windows in the back. They don't see anything. Everybody wishes somebody would have heard that child or seen that child. But you know what? This wasn't their child. This wasn't their car. They hadn't been inside that car with that child that morning. They hadn't gone back into that car at lunch. They hadn't got back in that car, inside it, at the end of the day. That's a red herring. Accident. The defense talked about accident again, and they skipped over the part again. They just skimmed over it. Remember, accident only applies if there is no criminal negligence. If there is negligence, you can't apply accident. Accident does not apply in this case. Again, well, we should say it's an accident. The defendant tried to tell him it was an accident. Well, of course he did. It would be preposterous for him to say, you know what, I intentionally murdered my child, cuff me. No, that would not have been according to his plan. And this argument about all murder counts are the same. Are we in the same courtroom? Didn't we go over the law on this? Didn't we talk about the different mental statuses for the different types of murder? We absolutely did. These are not the same types of murder. They gave you an example of crossing the street with kids, knowing that it's bad traffic. Actually, if you look at the law, as we went over and we talked about what the elements are, that could be cruelty in the first. That's actually more serious than a criminal negligence. You walk across knowing that your child may get hit. That's not a good example. Example 2, possibility of leaving a child in a car to run into an office and something bad happens. A, it's got to be foreseeable. B, yeah, they probably get charged with the crime too. You're right. Here, the knowledge is the knowledge of the danger. And that he should take precautions instead of paying attention to his other life. He knew the dangers of this more than anybody. He knew the dangers, if he really forgot, he knew you can take all these precautions to guard against it. And if he was fatigued like they tried to sell you on, guess whose fault that was? That was his. But ladies and gentlemen, this was no negligence. This was intentional. The false memory, and this is one thing key. The defense said, you know what? We know he had that false memory created when he got to Home Depot. No. For this thing to make sense, this whole crazy argument, he would have had to have created that false memory, oh, I've already taken him to daycare, before he even got to the light. He would have had to already have that in his head. Oh, I've taken him to daycare. Thus, I've forgotten. That doesn't make any bit of sense, ladies and gentlemen. Not a bit. Because he would have had to have forgotten before he made that turn. And then we talked about Elizabeth Smith and cleared that up. So y'all are clear. That was way earlier than taking the child to daycare. Okay. Another argument. The state's not going to address ill will or hatred and that issue. Obviously, they must have done their PowerPoint before I got up and talked because Yeah, I addressed that head on in our first close. So yeah, we addressed the issue of ill will or hatred, and we told you that's not required under the law. And you heard from the defense witnesses, you heard from everybody, you know what? While this person may on one hand love his child, if history has taught us anything, humans are capable of awful, awful things, especially selfish humans who are obsessed. Also, the state's intense hatred. We said there was intense hatred. We never said that once. There were witnesses who said Ross was a good dad. Tons of them. I'll say that everybody that came in this courtroom that had worked at Little Apron or were friends with the defendant, they said he appeared to be a good dad. Daycare workers more than anybody know. What you see with the family that comes in there to daycare, not always exactly the family and the person that you're going to see behind closed doors. No one, none of these people, this defendant was so good that nobody that came in this courtroom, even the people closest to him, knew what he was involved with. Not a single one. Also, he was a good dad. He loved Cooper. Well, he also allegedly loved Leanna. And we saw how that went and how he treated her. And Defendant's Exhibit 65. The defendant argued about this in their closing and said, well, he must have forgotten Cooper. Because, see, he messaged somebody and said he's awesome an hour after this. A, if he's mentioning Cooper an hour after this, he full well has not forgotten his son. But B, they're trying to argue it here one way. It's exactly the opposite of the way they did in opening. Remember in opening, when they said they got the times wrong? That's one of them. Exhibit 65. Exhibit 65 in opening, they said that was done before he dropped off Cooper. That's not correct. Now they're changing as the evidence changes. In their eyes, they're trying to change their argument. And he said, yeah, my son's awesome in response to one of the comments of that whisper poster. He wasn't going to respond, yeah, I'm killing my son right now. That's not what he was going to do. Okay, the vacation. Let's talk about it. These are all things that we brought out in our case in chief. We're not hiding from the facts because these facts actually support the state's case. Let's talk about the entirety of what this vacation evidence is. I'm not going to get up here and throw papers on the ground and, the state just disregarded it. Let's look at let's be adults about it. Let's look at what the evidence actually is. Okay? Vacation. They talked about throughout this entire case how the defendant would talk about stuff he really didn't mean or talk big about things. There's no doubt he wanted to go on a vacation. We know the day before the death he had Googled a sandals vacation with Antigua. He talked big, he thought big, absolutely. June 9th, when they had this text conversation, he Googles, and let's keep in mind remember he's already complained about how expensive kids are and things like that in posts. Remember, June 9th, do kids cruise free? Can kids cruise free? Things like that. June 18th, that late night, early morning, 12:48, Google. Passport fees. He's not Googling anything like, how awesome is a trip for a kid, or what are the accommodations, or anything like that. But again, what is the real timeline here? What is the real timeline of this stuff? June 9th, there's this text conversation. Michael Bajents, he's going to follow through. He's actually gotten his kids passports in preparation to go on a vacation. What has defendant done over there? Googled something one day and then did not a thing. And that's why these texts were important and why he didn't go into them, was because they show the defendant is guilty and they show that their recitation of this is not accurate. On the 17th of June, Amy Bajents texts the defendant. Hey, have you talked to that travel agent? The defendant responds later that afternoon, yeah, I'm just waiting to hear back from her. And we saw the evidence. He hadn't talked to her. He hadn't done a darn thing. What did he do? Then he sends out an email a couple of minutes later and sends it on to Heather Coyle. Why didn't the police go talk to her? well, we'll cover that in a minute, but we had the email from her, and guess what? He never responded and never did a thing that day to that email. So anyway, what's the real timeline? They email back and forth, and then that morning, he gets an email. At 9:35, 10 minutes, actually less than 10 minutes, after leaving that child in the car, he gets an email back from her about details of a vacation. There's your trigger. There's one of those things that Dr. Brewer told you, yep, that's going to make it less likely this was some fault, this memory failure. Not only that, he Googles, in a brief seconds period of time, Carnival Elation, which y'all are going to have this with you. You're going to have the emails. It was for 5 people. It was almost $3,000. It was not a vacation for Leanna and Cooper. It was not a vacation room for them to be in. Did he ever Google any of those other rooms? No. Did he ever forward that email to the Bajans? To Leanna? To anybody? No. You know what? This big thing about how would he have been Googling vacations June 9th? How would he have web searched something if he intended on killing this kid? Hours before he did it. I'm not up here saying that he wasn't conflicted about it. Common sense would say he probably vacillated back and forth until the opportunity presented itself, and he finally pulled the trigger. House hunting, concern for a good school. Okay, we didn't bring that up because guess what? In the email the police had, in May, he told the realtor, you know what, we're not going to be moving anytime soon. We don't have any immediate plans to move. They also argued the defendant was already doing what he wanted. This man was obsessed. He could not get enough of what he had going on. And he could only get it when the opportunity presented himself. Of course, this child was a burden that was in the way of doing exactly what he wanted to do as much as he wanted to do. What does he have to gain? Well, he doesn't have to worry about taking care of his child anymore. He doesn't have to worry about that responsibility. Oh, he's going to destroy his job. Ladies and gentlemen, he told y'all through his statements and everything, he thought he was going to be an advocate. He thought this was going to work out just peachy. Jim Persinger and the Griffin Psych thing. Well, first of all, yeah, I'll tell you that. We got to eat that one. That, the way the witness said, okay, Griffin psychology, this, that, and the other, that was wrong. I mean, that was just flat out wrong. But Mr. Evans got up there and corrected it, like, sir, were you aware that, you know, you did this last second thing? Were you aware that the defendant actually had an innocent explanation for it? Well, no, it wasn't. We weren't hiding that. Was it wrong? Absolutely. And you know what? Write a letter to us about that instance, complain to the county commissioners up in Cobb County, do whatever. Do not do injustice for Cooper because of that. Okay, everyone, and regardless of that, everybody here, even the defense expert, says that there's no web history on that phone before June 17th. We're not sitting up here telling you he went in and intentionally deleted it all. What we're saying is the defense argued there's no evidence on his phone of any of all this other stuff. Well, the reason, if there were, there wouldn't be any because there's no web history before June 17th. Incriminating stuff on the phone, we already talked about that, about why it would still be there and what is most important to him. Okay, mistake of fact. Please listen to this part, please, because the defense, again, in their closing argument, just told you one part of it. They read you the charge on mistake of fact. Again, what they left out and what they did not tell you is that if it's due to negligence, it doesn't count. You cannot use mistake of fact. If for some reason, under the sun, he had created some false memory before he even gets to that intersection that he had dropped the child off at daycare, it doesn't apply if it's due to his own negligence. Okay, it was routine. They talked about it. The 2 days he would drop off Cooper. The defense said, yes, there were 2 days on those receipts that he had dropped off Cooper and then went to the Chick-fil-A. And guess what? On one of those 2 days that he went to Chick-fil-A after dropping Cooper off, he remembered to get his guitar, not a living being, out of the car, out of the back, and take it in. Chick-fil-A didn't screw him up on that day. Redmond, Mr. Redmond at Chick-fil-A says he's not usually out there for breakfast. The defense tried to sell you this like he'd never seen Cooper before. If y'all remember, I know it was weeks ago, but Chris Redmond sat up there and told you, you know what? If I'd have seen him in the store, it would have been most likely at lunch. I'm not out there during breakfast. And how do we know? They said, you know what? We only have objective evidence of 2 occasions that he came in Chick-fil-A. June 18th and March. It's not true. Unless they're calling their client a liar. He said, yes, I go in there 2 or 3 times a month. Not only he said that, Leanna said, at the day of the incident, on the day of Cooper's death, yes, he would go every couple of weeks. And not only that, the little Apron Academy employees told y'all, yes, there were occasions he would go by Chick-fil-A with Cooper before they came to daycare. In fact, the defendant got Azor Hawkins and them some Chick-fil-A one day. And I think that was in April. Okay, the placement of the car seat for the 3D scans. First of all, the state did not even introduce those photos. They didn't even introduce those photos regarding the car seat and the little thing that's up or down on the car seat. Now, we went in and it wasn't addressed that we went in and the photos and the scans that y'all got were accurate. That wasn't rebutted at all. What you were presented by the state was absolutely accurate. And you know what? Nobody noticed it. Give it to the defense. They saw that. They absolutely caught it. And you know what? We wanted to make sure that you guys got what is accurate. And not only that, y'all are going to have the photographs. Y'all are going to have them back there. If you're looking at those car seats, look at the difference it made. It wouldn't have made one inkling of a difference as to whether the defendant saw that child. There's no doubt. Look and compare those photographs. And then the defense put up those photographs and showed you photographs that were introduced by Leanna's mom in the car seat, first of all, in April of 2014. Also from a perspective that was nowhere even near what a person in the driver's seat of the car would be seeing at night, in the dark, with the child leaning forward. Obviously, Cooper was not happy to be in that car seat at that time. And not done with measurements. Not done on the day of the incident of how that car seat was. The car seat had been taken out before then and after and put back in that car. We know how it looked June 18th. And consider this. That was based on measurements and measurements of the child at the time of his death. The medical records that got introduced, Cooper was just over 31 inches back in March. He was 33 inches at the time of death. He was 2 inches taller. And also, the person who brought those photos in and tried to tell you that those were how Cooper looked in June of 2014, she told you also that the doll's head was bigger than Cooper's. That's not true. Y'all are going to have the photographs of that doll's head being measured 18 and a half inches. Detective Stockinger had the medical records. Even in the medical records, in March of 2014, 3 months before Cooper's death, the child's head was already larger than the doll's. He was 19 inches, the circumference of the child's head. So it just shows right there. I'm not saying her mom's lying. But her perspective is different than actual objective, subjective evidence. And the objective evidence is we actually gave the defendant the benefit of the doubt. That doll's head is actually smaller than Cooper's would have been on the day of his death. All right. going to go back now to just going through some of the witnesses. Not going to go through what everybody said or anything like that. Just to remind y'all who the people were that are testified and generally what they had to say. Okay, we've got all the people at the scene. Now, what did all these people say? From Officer Piper, Gallimore, Hawkins, the civilians, on and on and on. What did we learn from these people? Back like 4 weeks ago, 5 weeks ago. Well, we learned the car seat was inches from the defendant. We learned where it was positioned. It would have been impossible not to see that child. We learned that the defendant not once, not twice, but 3 times had gone back to that car. Not once, not twice, but 3 times had been in a position to see that child's head. We knew that, and we learned from the photographs there, the work bag was to the right. We saw that the back and rear passenger windows were tinted. The front windshield and front door windows were not. And y'all saw that it was small inside of that vehicle. We also learned about the defendant's demeanor, how it was inconsistent, that he never called 911. What would any reasonable person do? They would have called 911. And he put that child on the hot pavement and walked away while strangers tended to him. He had a history that Officer Piper and Barwick said that he didn't do a second look. Already within minutes, talking about he had not done his second look. And you could tell he was not expected to get it. He did not expect to get detained that day. What else did we learn about the scene? Well, first, we learned that within minutes, this person who evidently, allegedly, has just realized that his child is dead and it's his fault. And he's in the back of that patrol car complaining about it being too hot. Looking out around the scene, and you saw the video where he would yell and he'd look around and be fine. You saw that he was interested in his phone. He was talking to Piper about being in law enforcement. And you saw right there, if there was any doubt, you're like, maybe he couldn't hear him in the car or something. No. Officer Piper was in the car, leaned down with a barrier in between, and the defendant in that setting could hear him just fine, could hear her just fine. Okay, the other employees, I think you kind of got the gist of what we're doing here. So I'm not going to go through slide after slide of all these details of everything that y'all saw, because now we're getting a little bit closer in time to when where we are right here today. The Chick-fil-A employees and Home Depot security. We heard from Kyle Weston and Chris Redmond about his time at Chick-fil-A. We know that he's a regular in the restaurant and in drive-thru. We learned from these witnesses, from Greg Sanders, that found out he'd come back to his car at lunch, was in the car over 30 seconds, sped out that afternoon, and Greg Sanders confirmed that those times were accurate. You heard that from these records from Little Apron as well that they got from security. The defendant was the one to bring Cooper almost all the time, at least 80% of the time. And let me just say this, going back to, I know we talked about Detective Stoddard and that in the frame. We had numerous witnesses say, yes, you have a clear view in the frame. Greg Sanders even said, yes, he is in the frame. If you look in there, there's a clear view. So just to touch on that, because that was in my head. Little Apron Academy, you heard from Melanie Gibson, Azure Hawkins, Kiata Patrick, and Michelle Gray. The defendant brought him most mornings. He called if he was going to be running late. He didn't call if a kid did not come into school, and the defendant full well knew that. And Leanna admitted that she told them that Cooper was in the car and that's the only place he could be. They told you the defendant went to Chick-fil-A with Cooper sometimes and then brought him in. And that when he brought Cooper in, after having gone to Chick-fil-A with him for his big father-son breakfast, that Cooper was always awake. We heard from Winston Milling and Alex Hall. They talked about the kind of the actions of the day. Y'all are going to remember all this. You heard from Regina and Brandon that he cared enough to bring his guitar in one day, a week before this. You heard from Winston and Alex that it was decided the night before they were going to go to that movie. And then they were going to go at 5 p.m. The defendant said he was actually going to possibly pass on lunch. And then said, you know what, I'll go if y'all drive. They also told you that it was unusual to drop the defendant off at the car. No reason he couldn't take light bulbs in. Let's talk about that for a second. First of all, as far as the return to lunch, look, this screen, you can't see these photographs very well on this screen. Y'all are going to have these enhancement photos with you back there in the jury room. You got 7:45 here, 7:31, 7:23, 7:36. I'm going to ask you to look at all these. And look at all these enhancement photos when you're back there. You tell me, when you stop frame by frame looking at these photographs, what he was doing. Y'all just look at it and let me know. Regardless, let's just say you can't tell what he's doing when he walks away. Let's just say that. You can't say if he's looking back or not. Remember we talked about circumstantial evidence? What makes good common sense? What makes common sense about why he did those things? He had left his son in the car. He came back to that car. As y'all saw, as the defense admitted, when you open up that car and you're there inside the frame, you have a clear view inside. As you're approaching, before you get to the frame, you have a clear view. And then he avoids putting his head in. Let's think about that. What makes good common sense? Why would he come up to a car, open the driver's side door, not go to the passenger door, not go to the back door to put these in, not go into work, into the driver's side door, open it, and instead of getting in to put it down, stop and keep your head up and throw light bulbs? Who throws light bulbs? Why would you throw light bulbs? Because you didn't want to get in the car, because you knew what was in there. What else makes common sense? A person passes by him and stops. The defendant stops. Pulls out his phone, as you're going to see in those frame pictures. Doesn't have it out immediately. And at some point holds it up. And then after the person walking by clears the car, he starts walking again. Common sense. What's the explanation for that? Of course, he was worried that person was going to go by the car. There's a saying that coincidence is a messenger sent by truth. Well, there's also a saying by Yogi Berra that that's too coincidental to be coincidence. Gotta love Yogi Berra, rest his soul. And I think we all get what he's saying. I think what is the saying? Shame me, fool me once, shame on you. Fool me twice, shame on me. All right, the rest of the detectives, we had the high-tech detectives, we had the expert witnesses, we had the other detectives in the case, we had the evidence of the double life. Again, the stills you're going to have back there. You know, quite possibly beating a dead horse, so I'm going to skip through these last few slides, which actually, I told you all of it in opening, and guess what? We've stuck to our promises, and we've told you everything in these slides. We told you what it was going to show, and we did show it. His post-interview statements, malicious intent, the triggers. Y'all are going to remember all of these triggers. Dr. Brewer had to answer the questions about them. These, again, through the defense's own expert, show this defendant is guilty. The triggers. Get to work okay? Yep. Cooper's name right there above it. All those triggers. things that were not his routine. Not routine to skip lunch in order to work. Not his routine to have friends drop him off at his car instead of the office. And think about it. When he asks Leanna at the end of the day, 3:16, what time are you picking up my buddy? The defendant knew full well she was picking him up. The only reason he would have had to ask her what time she's picking him up is she's checking as to when she's going to leave to get there. He had no other reason in the world because he was going to the movies that night. Again, the knowledge and state of mind, the advocate, the look again campaign. How hot does it get in a parked car? And the defense argument about this jury view. The defense, to you, admitted it was obvious to anyone. And none of you actually got in the car. The defendant was in the car that you saw that morning with that child. He was in there with him that afternoon, and those people that walked by never went inside that car like the defendant did. Common sense and these reasons show this defendant is guilty. We talked about justice. I know this has been a long several weeks for y'all. I think it has been for everybody. And you know, one of the things we can get caught up in our jobs as far as attorneys is, you know, arguing about the law and arguing about semantics and word games and things like that, and kind of forgetting why we're here. You know, a lot of times attorneys will make excuses for common sense. Excuses that distract us from what is so obvious and right there in front of you. Now, we've heard a lot in this case about wordplay, talked about burdens of proof, argued over legal terms, you've heard objection, you heard some jawing back and forth between the state and defense. Right here, right now, let's get back to what this case is about. This case is about justice, and it's about that little boy, Cooper Harris. Today, that boy would be 4 years old, in pre-K, getting ready to go to kindergarten, maybe learning how to play t-ball. I guess as much at that age you have to learn how to He's not here with us because that defendant took him. That defendant took his life for his own selfish, obsessed reasons. That little boy's never going to get that chance. And those chances he would have had. We've heard a lot about excuses for this defendant, which have been turned away at every stop. But who's going to speak for Cooper? Who speaks for Cooper? The witnesses and the officers at that scene who carried that burden of what they saw that day, who cared more about that child on June 18th than this defendant. Defendant who was concerned and crying finally when he was worried about the metal toilet he's going to have to use the bathroom in and the uncomfortable cot. Woe is me. The child was dead. The evidence speaks for Cooper. And they can't bring him back. But what can be done is justice. And you as a jury have the opportunity to do that justice. Now there's a Latin phrase that hangs over the Supreme Court. And I'm not going to say I know Latin, I can speak Latin for the darn, but I do know what it says. And it translates to this. let justice be done, though the skies may fall. In this case, justice is justice for Cooper in that call. Justice in this case is a verdict of guilty. Justice in this case is holding this defendant responsible. Thank you.
Ladies and gentlemen, close your notepads. Also move for a short recess. Open mind, no conversation. Y'all take a step back.
All rise. Please watch your step going down. Please watch your step going down. Please be seated. Please be seated.
Has the state had a chance to review the charge to be sent with the jury?
I briefly read over it, yes, Judge. Skimmed it. I'd like to look at it a little bit more during the break.
Okay.
Are we going to take a break?
Yes, because I figured you were going to look at stuff. I
Yes,
mean,
ma'am.
seriously. And they're taking a break, so we have to take a break. I'm looking at my watch to see what's a reasonable period of time. Can we meet back at 5 till?
Yes.
I'll tell you what, if you all want, I'll just send the staff attorney and talk to each side to see if you've got suggestions or problems, see if I can iron them out. Is that okay with everybody if I do it that way? Take 10 minutes. I'll send Ms. Walker and Ms. Collins in after that.
Yeah.
Just to make life a little harder.